Fred loved Nicholas from the first moment. In fact, that day he made him a promise. But Fred's promise is just the beginning.
Let's talk. Because this situation has gotten out of hand a little bit too much. So, they tried to say that I don't know. I'm going to just let y'all listen. Because y'all need to hear this. So
it's not unexpected, but it's still significant that the Omicron variant.
Let's go over to the video.
In the U.S. right now in California, we still don't have a total read on how dangerous it is or whether it's spread, but the message from the White House is very clear. Don't just get vaccinated, get boosted.
Every time you manage.
Oh yeah, I'm gonna go over here now and play it.
Hello everyone, I'm Lana Zach. Thanks so much for joining us. The parents of a teenager accused in the deadly Michigan high school shooting have pleaded not guilty to multiple charges. James and Jennifer Crumbley were arraigned Saturday morning. Prosecutors charged them with involuntary manslaughter, and the judge set bail at $500,000 each. Police found the boys hours earlier in a building in Detroit, about 40 miles from their home. Officials say the couple skipped their first court appearance Friday, which triggered the manhunt. While police were looking for the parents, the community in Oxford, Michigan held a vigil Friday night mourning the 4 students killed in the shooting. 7 other people were wounded. CBS News' Michael George has the latest.
Facts of this case are so egregious.
Oakland County Prosecutor Karen McDonald expressed her astonishment at the events that led up to the shooting at Oxford High School, saying the actions of Ethan Crumbley's parents went far beyond negligence.
Any individual who had the opportunity to stop this tragedy should have done so.
McDonald offered new details into Tuesday's shooting, revealing that Ethan was with his father on Black Friday when the gun was purchased, and that Ethan and his mother had made social media posts about it. Ethan just got my new beauty today, and Jennifer Crumbley writing over Thanksgiving weekend that it was a, quote, mom and son day, testing out his new Christmas present. School officials became concerned on Monday, a day before the shooting, when a teacher saw Ethan Crumbley searching for ammunition on his phone. His mother was contacted by the school, but phone records show she told her son in a text message, quote, LOL, I'm not mad at you. You have to learn not to get caught. On the day of the shooting, prosecutors say a teacher found a...
So she's basically trying to say you have to learn not to get caught. When he got caught basically drawing a gun with blood. So that's really indicating that that's a red flag.
Nicholas grew more generous, and eventually he fulfilled his mother's prophecy. In manhood, he became the saint.
That's basically a red flag. And then his mom saying, LOL, I'm not mad at you. You just gotta learn to not to get caught. That's basically her literally like making a joke, trying to say that it's funny that he's in here drawing guns and stuff, and an actual gun and bullets, and then looking it up. That is very like, if that's like suspect right there. But we'll continue.
A note on Ethan Crumbley's desk depicting violent images and messages.
In another section of the note was a drawing of a bullet with the following words above that bullet, quote, blood everywhere. Further down the drawing are the words, quote, my life is useless, end quote. And to the right of that are the words, quote, the world is dead.
Crumbley's parents were summoned to the school and told to get him into counseling within 48 hours. They resisted the idea of taking him home. The 15-year-old returned to class, and prosecutors say he then carried out the shooting. Upon hearing the news of the shooting, Jennifer Crumbley texted her son saying, Ethan, don't do it. James Crumbley called 911 to say that a gun was missing from their home and that his son might be the shooter.
I expect parents and everyone.
He basically said the world is dead, so I guess it was going to be more than one shooting. Or, I don't get that quote, the world is dead. I need someone to explain that to me because I still do not get what he meant by the world is dead. Like, what do you mean by that? The world is dead. And you had all of this drawn on the picture. Like, that is very creepy at this point.
To have humanity and to step in and stop a potential tragedy.
CBS News legal contributor and Loyola Law School professor Jessica Levinson joins us now. Jessica, every time we hear more details, we're just sort of stunned by this. Let's start off with the parents. How much does the parents leaving their home, skipping their first arraignment, triggering that manhunt, how much does that factor into their case?
It will. The prosecutors will use it to show consciousness of guilt. The prosecutors will argue, look, innocent people don't flee. Innocent people turn themselves in, say, what can we do to help? Here's what we know. Now, I understand that their explanation has been, well, we need to leave for our safety. Frankly, just based on what we know now, their actions don't add up to that. Their actions very clearly look like they were people who just did not want to be arrested. And so again, the prosecutor now has evidence to indicate that these are not people who, at the very least, were willing to help in law enforcement. And that at the most, that this shows that they understood that they themselves could face criminal liability here.
Well, the attorney representing the parents released a statement following their arrest.
It's in part, while it's human nature to want to find someone to blame or something to point to or something that gives us answers.
Why do I feel like that with this situation and his parents running and things like that shows us that they allowed him to, like, it's not like, no. You basically allowed your son to kill people. Like, that is not a good thing at all. It is bad. I don't like this. They just do too much. Like, I hate to say it. They do too much. They do too much. They do too much. They do way too much. So let's get back to the video.
The charges in this case are intended to make an example and send a
message. Jessica, what does this tell us about the defense's strategy potentially in court?
I think what they're going to say is that these are novel charges, or the defense when it comes to the parents, of course, is that these are novel charges that you should not have gone from charging their son, the shooter, and then stretch that kind of one more link to the parents. It basically shows, I think, their strategy is, look, we know you're upset. We know this is a tragedy, but don't try and now impute this onto my clients. Don't try and impute this onto the parents. And I think what they'll say in general is you can't draw this line. You can't make this connection from what their son did to their being criminally liable here. And I think that will be, frankly, most of their defense. And again, I think they're emphasizing this idea that, well, we don't typically see charges against parents, so there's something different here. It's an aggressive prosecutor who's just trying to, make a political statement.
So explain to us how prosecutors did settle on charging the parents with 4 counts of involuntary manslaughter, and what will they need to prove in court?
So what they're going to need to prove is that defendants acted in a grossly negligent manner and that their actions, either their affirmative actions
or their omissions, their failure to act under Michigan law, helps to.
You got that right. They did act in a negligent manner. They allowed their kid to kill people.
cause the death, of helped to cause this tragedy of the students, that essentially their actions were what we would call in law school kind of the but-for cause of these tragedies. And so why would, you asked me, why were they charged? I think that one thing that's really important to emphasize is that the parents aren't being charged because they're parents of a troubled teen who knew their teen was troubled. As we just heard in the introductory package, they had significant involvement. They helped to purchase the gun. They knew that their son was looking for ammunition. The mother sent a text saying, LOL, basically, I'm not upset, just don't get caught. That they were called into school, that they were told there's disturbing things here, and that they refused to essentially take him out of that dangerous environment, that by leaving him there, that they helped set all of this in motion. And not just, again, leaving him there, but buying the gun, being aware he was looking for ammunition, being aware that there were troubling signs from the school. Now, they might respond, look, if it was that dangerous, then the school shouldn't have allowed him to go back to class. And that's another part of their defense that we may see. But again, want to emphasize, they're not being charged because they're parents who knew their son was troubled. They're being charged the same way any adults who were involved in a minor obtaining a gun and being aware of the minor's actions would be charged.
The suspect is facing 24 charges, including terrorism causing death. We talked a little bit about how the parents' aspect of this makes this case different from other previous school shooting cases. What else stands out to you, Jessica, in terms of how this one is different from things that you've seen before?
Yeah, so obviously the charge against the parents, well, I think it is different. The parents, again, have a different level of involvement here than what we typically see, a different level of awareness. Now, with respect to the terrorism charge, I think one thing that's important for people to know is that Michigan, after 9/11, did enact this fairly broad state law that allows you to charge people who intimidate or coerce either a civilian population or government actors by their actions. Now, I'm being a little broad here, but Michigan, in fact, does have a very broad state law dealing with terrorism. Now, people argue that was really intended to be used just for terrorist acts. And that's how it's typically used, that, I think somebody sent in a bomb and you would charge them under that terrorism statute. But in this case, what the prosecutors are really saying is, think of what happened to those kids inside the classroom. Think of what happens in a school shooting. And Michigan does have a history of using this particular statute more broadly. I believe they used it in 2012, dealing with somebody who was in his car, basically on a shooting spree. So that is something also different that we're not typically used to. And then, of course, we see the typical charges of, first-degree murder, intent to commit criminal assault, and so, certainly we'll be following the case to see if other states would follow suit.
All right, Jessica Levinson, thank you.
Thank you.
So we're gonna also now watch the arraignment video. So, yeah, let's get into it.
the prosecutor's office, can you hear the court?
I can. Thank you, Judge.
I can't. Jeff Rector from Pretrial Services, can you hear the court? The GPS tether must be installed upon release from the Oakland County Jail. The GPS tether will have the allowances that she could go to work, attend court hearings, medical appointments, and attorney meetings. She must provide work schedule, medical appointments, and any meetings to PTS in advance. Again, that must be installed at the jail before she leaves the jail. As it relates to James Robert Crumbly, the court is setting a $500,000 cash surety, no 10% bond. The defendant is not to use or test positive for alcohol, recreational marijuana, or any controlled substances. The defendant is not to possess or have in his possession any firearms, weapons, or ammunition. The defendant is not to have assaultive behavior toward anyone. The defendant must provide a release address if he is able to post bond to Pretrial Services. He will be monitored by Pretrial Services, must submit and pay for ETG, PBT, and a urinalysis within 24 hours of release from the Oakland County Jail at a facility that is open 7 days a week, that automatically lab confirms all positives, provides all levels in writing. The defendant must verify employment to PTS upon release from the Oakland County Jail. The GPS tether must be installed prior to release from the Oakland County Jail in the event that the defendant is able to post bond. He also must provide information relative to employment schedule, medical appointments, or any other appointments that are allowed, which will include, he could attend court hearings, employment, medical appointments, and attorney meetings. Any violations of any of the terms and conditions of those bond may result in revocation of bond. Any questions as it relates to bond for James Crumbly?
Your Honor, we have no questions, but I do need to place one thing on the record. I'm not asking the court to change anything. What I want to state on the record is I was not able to watch the entire press release and what I had no idea there was a 4 o'clock arraignment. Ms. Lehman didn't know either. The media had so many reports of random times that, quite frankly, we didn't believe.
Counsel, we're not going to get into.
I just want to apologize to the court because we weren't aware. And also, we faxed over appearances and no one told us, like, hey, we're going to do this at 4 o'clock. We sent appearances late in the day. And I just apologize to this court because we don't miss dates. So thank you.
Thank you. Finally, as it relates to bond, in the event that the defendants do post bond, I am requiring that they turn over any and all weapons to the Oakland County Sheriff's Office. That must occur within. Realistically, I'm not sure what they have in their possession or if they're going to be able to be where they're going to be released to if they post bond, but I am going to require that they turn over all weapons upon release from the Oakland County Jail. Okay, any other questions?
No, thank you.
No, Your Honor.
Thank you. All right, again, the PCC is on the 14th at 1:15. Preliminary examination is on the 22nd at 9:45 a.m. It will be in-person proceedings. Please make sure that you are prepared with all witnesses and or exhibits.
Your Honor, I just do want to put on the record that there are hundreds and hundreds of hours of digital evidence and voluminous documents, and we are compiling it, and we'll get it to defense counsel as soon as possible.
Okay, thank you.
Thank you,
Your Honor. Have a nice day.
Thank you, Judge.
You too.
Your Honor.
Okay, so that means I'm gonna have to redo it because it only said, I think, the ending, and I don't know what's wrong with this thing, but we'll go back to it. So y'all can watch the full thing.
First, I'm going to start with the defense to hear the court.
Yes, Your Honor. Good morning, Judge.
can you hear the court?
Yes, Your Honor.
Good morning, Judge.
Okay, Mark Keast from the prosecutor's office, can you hear the court?
I can. Thank you, Judge.
I can't.
Jeff Rector from Pretrial Services, can you hear the court?
Yes, Your Honor, I can.
Jennifer Crumbly, can you hear the court?
Yes, I can.
Looks like we're still trying to get James Crumbly set up there. James Crumbly, can you hear and see the court?
Yes.
Okay, Karen McDonald, can you hear and see the court?
Good morning, Judge.
Okay, we're all set. I'm going to go ahead and call these cases separately. I'm going to call starting with People versus Jennifer Crumbly, docket number 21006-652. Can I have appearances on the record, starting with the prosecutor?
Karen McDonald, on behalf of the people of the state of Michigan.
Mark Keast on behalf of the people.
Good morning, Your Honor. I'm Shannon Smith on behalf of Jennifer Crumbly.
Good morning, Your Honor. Marielle Lehman on behalf of James Crumbly.
I do want to address one issue first. Ms. Lehman and Ms. Smith, you are practicing in the same firm, is that correct?
Your Honor, that's correct. We have spoken to both of our clients about conflicts of interest. We have had in-depth conversations with them. Marielle Lehman and I are representing both of them. We are representing James and Jennifer, and the conflict of interest question or issue has been very much discussed and resolved. And we believe at this time, ethically and professionally, we can continue on in this fashion.
Okay, well, as you know, pursuant to MCR 6.005, subsection F1, you must state on the record the reasons that you believe joint representation in all probability will not cause a conflict of interest. So please state that for the record in accordance with the court rules.
Thank you, Your Honor. After reviewing the circumstances and facts of the case, and one of the things I need to make clear is that the media has very much been saturated with cherry-picked facts. But when we have talked to our clients in depth and learned all of the circumstances of the case, which obviously are covered by attorney-client privilege, there is not a conflict of interest between what happened. Without, I cannot divulge to you.
Okay, I don't think those facts was cherry-picked. I think people had actual facts and they dug deep into why he actually felt like it was right to, shoot the school up and kill people who was innocent, because those people who died and got injured did not deserve that. They deserve to live their life, and for the ones who did die didn't deserve to be stripped of their life. They deserved to live their life without being harmed, and it didn't happen. And right here, people defending them like it's right. No, it's not right. It's basically you condoning what they did and basically saying it's okay, which is not. It's not okay at all for them to allow their son to take a gun to school and then harm people who didn't ask to be harmed.
The specific reasons, but there is not a conflict of interest between the parents, their defense, and their defense strategy.
Prosecutor, any comments or statements you want to make relative to any potential conflicts of interest?
Your Honor, I'm not sure that there's any facts that have been placed on the record that meets the standard. I'm not saying that I object, but I'm not sure that we have satisfied the court rule. But if Mr. Keast has something to add.
I am required to inquire as to each defendant as well. Jennifer Crumbly, do you have any objection to Ms. Lehman and Ms. Smith representing both you and Mr. Crumbly for this case, recognizing that they come from the same firm and they will be representing both of you?
I have no objection.
Mr. Crumbly, likewise for you. Do you have any objection to both Ms. Lehman and Ms. Smith representing both you and Ms. Crumbly as it relates to this particular case?
No objection, Your Honor.
Do either of you have any questions or concerns about a potential conflict of interest? Mr. Crumbly?
No.
Ms. Crumbly?
No.
At this point, the court is satisfied that both of the defendants are comfortable with both attorneys representing them in this case. The attorneys have indicated on the record that they do not believe that there is a conflict of interest and that they have spoken with both defendants in depth relative to any potential conflict of interest and whether or not their representation may jeopardize the right of each defendant to have the undivided loyalty of their lawyers. Therefore, the court will allow them to appear for purposes of the arraignment today on behalf of both defendants.
Thank you, Your Honor.
Great. Now, in terms of the arraignment, Jennifer Crumbly, I'm going to arraign you first. So if you'll please make sure you get close to that microphone so that we can hear you. If at any time you cannot hear or see me, please put your hand up and we'll stop the proceedings and then try to figure out what's going on. Do you understand that you are charged with the following counts? Count 1, involuntary manslaughter, which is punishable by up to 15 years in prison and or to a $7,500 fine and mandatory DNA for the death of Madison Baldwin. Do you understand that, Gerald? Do you understand that that is a charge for count 1? Ms. Crumbly, you need to verbally respond.
I understand.
Do you understand that you are charged in count 2 for the death of Tate Meyer? Involuntary manslaughter, which is punishable by up to 15 years in prison and or up to a $7,500 fine and mandatory DNA.
I understand.
Do you understand that you are charged in count 3 for the death of Hannah St. Juliana with involuntary manslaughter, which is punishable by up to 15 years in prison and or up to a $7,500 fine along with mandatory DNA testing?
I understand.
Do you understand that you're charged in count 4 for the death of Justin Schilling with involuntary manslaughter, which is punishable by up to 15 years in prison and or up to $7,500 fine along with mandatory DNA testing?
I understand.
Do you understand that you do have the right to plead guilty or not guilty to all those counts?
I understand.
And do you understand that you do have a right to a trial, either by jury or by judge? And at that trial, you would have the opportunity to call witnesses on your behalf, confront witnesses that have been called against you, and or to remain silent, and that you'd be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand all those trial rights?
Yes, Your Honor.
Are you on probation or parole for any other offense? Ma'am, I'll ask the question again. Are you on probation or parole for any offense?
No.
And how are you pleading to count 1?
Not guilty.
How are you pleading to count 2?
Not guilty.
How are you pleading to count 3?
Not guilty.
How are you pleading to count 4?
Not guilty.
The court will enter the pleas of not guilty for you for all 4 counts. The court will set the probable.
The fact she pled not guilty, no, you're guilty with all 4 charges. Same with his dad, guilty with all 4 charges. That's 8 charges altogether placed on the both of them combined. They're guilty. They shouldn't be let off or have no bond.
Cause conference, which is going to be on December 14th. Amy, what time do we have that one?
You could do 9.
That is December 14th at 1:15 p.m. The preliminary examination is scheduled for December 22nd at 9:45 a.m. Those will be in-person hearings.
Your Honor, just as a matter for our file, are you assigned for the purpose of exam and the pre-exam, or is it a different judge within the court?
It is me.
Okay, perfect. Thank you. Thank you.
I'm going to address bond in a minute. I'm going to go ahead and arraign Mr. James Cromley first. Mr. James Cromley, see and hear the court okay?
Yes.
And do you understand, sir, that you are charged in count 1 for the death of Madison Baldwin of involuntary manslaughter, which is punishable by up to 15 years in prison and or up to a $7,500 fine and mandatory DNA testing?
I understand.
Do you understand in count 2, you are charged with the death of Tate Meyer for the involuntary manslaughter, which is punishable by up to 15 years in prison and or up to a $7,500 fine and mandatory DNA testing?
I understand.
Do you understand that you are charged in count 3 for the death of Hannah St. Juliana with the involuntary manslaughter, which is punishable by up to 15 years in prison and up to a $7,500 fine and mandatory DNA testing?
Understand.
And do you understand that you are charged in count 4 for the death of Justin Schilling, involuntary manslaughter, which is punishable by up to 15 years in prison and or up to a $7,500 fine and mandatory DNA testing?
I understand.
Do you understand that you do have the right to plead either guilty or not guilty to all of those charges?
I understand.
Do you understand you have a right to a trial either by jury or by judge, and at that trial you would have the opportunity to call witnesses on your behalf, confront witnesses that have been called against you, and or to remain silent, and that you be presumed not guilty until proven guilty beyond a reasonable doubt for each and every element of the crime? Do you understand those trial rights?
I understand.
Are you on probation or parole for any other offense?
No.
How are you pleading to count 1?
Not guilty.
How are you pleading to count 2?
Not guilty.
How are you pleading to count 3?
Not guilty.
And how are you pleading to count 4?
Not guilty.
Again, the court will accept the plea of not guilty for all 4 counts. Your case will also be scheduled for a probable cause conference on December 14th at 1:15 and a preliminary examination on December 22nd at 9:45 a.m. At this point, I'm going to address bond. First, I'd like to hear from Pretrial Services.
Thank you, Your Honor. Jeffrey Record for Pretrial Services. Ms. Gardner declined to speak with Pretrial Services and requested to speak with their attorney. As a result, no references were contacted and little background information is available. She's 43 years old and married. Her listed address with the jail is 112 East Street in Oxford, Michigan. She does have a prior criminal history. She is not currently on probation or parole. She does not have a history of failing to appear. She does not have a prior documented history of violence. The charges against the defendant are severe, and those charges issued by the court. Defendant, along with the co-defendant, failed to turn themselves in to authorities. While every defendant is afforded the presumption of innocence, the purpose of bail is to ensure appearance and the safety of the community. Defendants in this matter had agreed through their attorney to turn themselves in to the court once charges were issued on 12/3/21. However, instead they fled. Based on the defendant's attempt to flee prosecution, Pretrial Services has concerns for appearance and the safety of the public. It is our recommendation that a release on recognizance bail is not appropriate in this case. In order to further mitigate concerns for appearance and public safety, if the defendant makes release, the following conditions are respectfully recommended. Pretrial Services supervision, the GPS tether prior to release, allowed to leave home for work if employed, medical appointments, attorney visits, not to have any contact with any witnesses, victims, or return to Oxford High School, not to possess a firearm, and must turn any firearms in that have not been confiscated.
Thank you. Who is going to speak on behalf of the prosecutor's office?
I am, Your Honor.
Go ahead.
Your Honor, I'm sure you've read the swear to you. Pursuant to MCR 6.106, bond should be set with the considerations of the likelihood of conviction first. Here, the likelihood of conviction is strong. Your Honor, we know from the facts and that were presented at the swear to that Mr. Crumbley purchased this weapon for his son, and that on the 27th, Mrs. Crumbley went to the shooting range with her son, posted on social media saying that it was a Mother's Sunday and that she bought a weapon for her, a gun for her baby for Christmas. It's also clear from the facts that he had total access to this weapon and that it was for him. Second, on the 29th, both defendants were aware that he was searching ammunition on his phone at school. Instead of reacting to that as a concerned parent and worried about safety, Mrs. Crumbly texted, LOL, just, I'm not mad, just next time don't get caught. And then obviously on this very tragic day, on the 30th, they were called to the school and about their son's drawing, which clearly depicted threats and acts of violence. And instead of disclosing to the school that he had full access to this weapon, they chose not to. They chose not to take their son home. They chose not to tell anybody that he might be dangerous when it was clear and they had every likelihood that he was. And instead they left. Furthermore, after the active shooting announcement went out, Mrs. Crumbly texted her son, Ethan, don't do it. And Mr. Crumbly went to his home purposely to search for this weapon because he was afraid his son had the weapon and was in fact shooting people and hurting them, which, as we know, is exactly what happened. Your Honor, this is a very serious, horrible, terrible murder and shooting, and it has affected the entire community. And these two individuals could have stopped it. And they had every reason to know that he was dangerous, and they gave him a weapon and they didn't secure it and they allowed him free access to it. Furthermore, Your Honor, the purpose of bond is to secure further court appearances. And yesterday, they were charged with these counts of involuntary manslaughter. Now, Your Honor, the communication between Mrs. Smith and the prosecutor's office was a text message that was sent to me and was not replied to. And we don't have an obligation to cooperate, and there are good reasons for that. And I think the fact that the events that played out show the reasons for that. Now, Mrs. Smith, clearly her clients did not tell her the truth, because her representation was they wanted to turn themselves in and that they were on their way to do that. However, they didn't turn themselves in, and we were told they were out of town, except that yesterday morning they withdrew $4,000 from an ATM in Rochester Hills, very close to the court where they could have turned themselves in with no events and no efforts on behalf of law enforcement. Instead, they fled, and they sought multiple attempts to hide their location, and were eventually tracked down after they parked their car somewhere. A witness saw it, and the entire fugitive apprehension team with multiple other law enforcement agencies went into a vacant building and searched it from top to bottom. And these two individuals were found locked somewhere in a room hiding. These are not people that we can be assured will return to court on their own. And then lastly, pursuant to MCR 6.106, we also should consider, or the court should consider, whether or not there are members of the community to vouch. There are none here. In fact, there are none here because there's not one person in that community that will vouch for these two defendants. So I'm asking that you set a $500,000 bond for both defendants, cash surety.
I'd like to hear from the attorneys. Please address bond as it relates to Jennifer Crumbly first, please.
Your Honor, the first thing I need to do is to respond to the prosecution's comments about our contact with their office. On Thursday night, I texted Karen McDonald and told
Well, I feel like they both shouldn't have bond because they need to sit in jail and learn from the actions they've caused and from the tragedy and nightmares and other things they've caused the town of Oxfield, and not just the town of Oxfield, everyone who has seen this. So they need to sit in jail, rot, and learn from their mistakes, or they're not mistakes, they're technically learn from what they did.
Told her my office was representing the Crumbleys and I wanted to speak with her. She did text back and said we could talk first thing Friday morning. First thing Friday morning, I did text Miss McDonald. I also group texted Miss McDonald with Marielle Lehman. I also called her office. I talked to her personal secretary and explained who I was, the circumstances, and that I needed to speak with Miss McDonald. Marielle Lehman also called Miss McDonald in the morning. We called the prosecutor's office throughout the day and never got a call back. We were going to make arrangements to have our clients turn themselves in. I was in a trial in circuit court in front of Judge Saban all day yesterday. Miss Lehman was traveling on a plane from Florida up to Michigan. The prosecutor's office, instead of getting back to us in any way, decided to have a press conference and, as Miss McDonald admitted, try to find a way to surprise our clients and catch them off guard when it was so unnecessary. And last night and throughout the day, we were in contact with our clients. They were scared, they were terrified, they were not at home, they were figuring out what to do, getting finances in order. And the last text messages we had with them and phone calls Marielle Lehman and I had with them, our plan was to drive to the Novi District Court this morning because arraignments were supposed to start at 8:30 for any county arraignment. And we had plans to meet them at 7:30 to text the fugitive apprehension team to get to the court by 8:30 so they could be arraigned first thing. Those were plans we made and solidified, and we did not announce it because, unlike the prosecution, we weren't attempting to make this a media spectacle. This case is absolutely the saddest, most tragic, worst case imaginable. There is absolutely no doubt. But our clients were absolutely going to turn themselves in. It was just a matter of logistics, and all the prosecution had to do was communicate with me about it. And we tried multiple times. All right, that being said, with respect to Miss Crumbly, she is 43 years old, as Pretrial Services told you. She has been employed as the director of a large company, director of marketing. She grew up in Clarkston. Prior to living in Oxford, where they've owned their home since 2015, she lived in Lake Orion. She has never been in serious trouble with the law. She does have a drunk driving conviction back from when she was in college. Any conviction on Miss Crumbly's record is a misdemeanor and is old. Miss Crumbly has retained my office and Marielle, obviously. She would not have done that had she planned to not turn herself in and fight these charges. I'm quite certain they would not have paid my office money and taken those steps if they were not going to fight these charges. When it comes to the seriousness of the offense, when you listen to the prosecution's facts they're presenting, which are incomplete, very incomplete, it does sound like an absolutely egregious wrongdoing on the part of Mr. and Mrs. Crumbly that they gave their child a gun and encouraged them to do this. That's just not the case. And Mrs. Crumbly is presumed innocent. And I ask this court to note that full discovery has not been available and that the court is only aware of the facts the prosecution has presented, but that gun was actually locked. So when the prosecution is stating that this child had free access to a gun, that is just absolutely not true. And
I'm trying to say it's not true. Okay. I'd like them two plus the parents, it should be locked up too. Because Oxford deserves justice. They need their justice now, not later, not tomorrow, not next week, not next month, not next year. They deserve it now.
And we need an opportunity to fight this case in court and not in the court of public opinion. We need the opportunity to have our clients' constitutional rights to being presumed innocent protected. And this court is going to see in the exam in particular that there is far more going on than what this court has been made aware of. And for that reason, Your Honor, I would ask this court to set bond, keeping all of that in mind. Our clients would absolutely avail themselves to a GPS tether. They would absolutely obey all of the conditions listed by Pretrial Services. This case does not warrant a $500,000 bond. I would ask this court, in light of the criminal history, the limited facts presented, to order that the bond be set at $50,000 or $100,000 if this court believes it needs to be more. Our clients are going to fight these charges. Our clients are just as devastated as everyone else. Bond has to come from a place of legal soundness, not emotional reaction, which has driven this entire case. And it is emotionally charged. It is emotionally the worst thing I have ever been involved with and seen. There is no doubt it is the worst thing the Crumbleys have ever been involved with and seen. And there is just so much going on here, and we ask the court to set a reasonable bond.
Any additional comments as it relates to James Crumbley?
Yes, Your Honor. James is 45 years old. He has a prior conviction from 2004. Again, similar to Jennifer Crumbley, any convictions that he has would have been, we believe that they were misdemeanors. He does not have any substance abuse issues. He does have some health issues that require, he's diabetic, that require 2 types of insulin. He was gainfully employed. He's been in Michigan since he and Jennifer moved up here several years ago. As for the seriousness of the charges, as Ms. Smith has stated, the facts that have been presented by Ms. McDonald and her office have been cherry-picked to further her narrative of making an example of Mr. and Mrs. Crumbley, which she very freely said she was doing yesterday during her press conference. Again, to echo what Ms. Smith has said, I personally contacted Ms. McDonald's office to notify her of mine and Ms. Smith's availability. She chose not to call us back. I was also in communication with law enforcement, as was Ms. Smith. They knew that we were planning to bring Mr. and Mrs. Crumbley in. They knew that we were in communication with them, contrary to what was presented in the media. Your Honor, they hired our office on Thursday. We are prepared to defend this case. They are absolutely taking this case seriously. They are devastated by the events in the Oxford incident. This is not something that's being taken lightly by them or us, Your Honor. I agree with Ms. Smith, $500,000 is not warranted in this case. The charges are very seriously, but as the court is aware, they are allegations at this point. As Ms. Smith has stated, both of our clients are presumed innocent unless they're proven guilty, Your Honor. And quite frankly, from what we know, Your Honor, the facts are not what they've been presented to the court and to the public. So I again echo what Ms. Smith indicated. Our clients are more than happy to have a GPS tether, to be on pretrial services supervision. I am again requesting a $50,000 or $100,000 bond. But Mr. Crumbley, as with Mrs. Crumbley, is not a flight risk. He is not a danger to the community. There is no risk that they're going to flee prosecution. They were never fleeing prosecution. I want to make that very clear with the court. We had been in communication with the prosecutor's office and law enforcement and our clients throughout yesterday, Your Honor. They were not fleeing prosecution, contrary to the media reports. So, Your Honor, I'm asking that they have a $50,000 or $100,000 bond with a GPS tether and pretrial services supervision.
Your Honor, may I respond, please?
Very, very quickly, please.
Your Honor, I agree with Mrs. Smith on one thing. The court hasn't heard all the facts, and neither has the public, because I have an ethical duty not to release those facts, because she is indeed correct. Her client and Mr. Crumbley have an absolute we have a burden, and these are merely allegations. So I agree. And I just want to point out, nobody needs permission. These defendants did not need my permission, and they didn't need law enforcement permission to go to the court and turn themselves in, go to the police department, the sheriff's department, and turn themselves in. I agree Mrs. Smith was perhaps in trial. She had a break from 11:45 to 2:45. And I can't imagine why they were surprised. The whole country knew that these charges were coming. And lastly, to suggest that anyone is somehow using this incident to create press, there's a lot of attention here because 4 children were murdered and 7 others were injured. And that is on the mind of every single person in this country. So I would ask that you impose the $500,000 cash surety on each of the defendants, Your Honor.
Thank you. So in terms of bond, the court is required to comply with MCR 6.106. The purpose of bond is to ensure that the defendants appear in court for all necessary court appearances, as well as to take into consideration any risk to public safety. Obviously, these charges are very, very serious. There's no question about that. The court does have some concern about the flight risk along with the public safety, given the circumstances that occurred yesterday and the fact that the defendants did have to be apprehended in order to appear for purposes of arraignment. The court did indicate yesterday after the swear-to that it would be conducting an arraignment at 4 p.m. And nobody appeared for purposes of that arraignment.
Your Honor, excuse me.
The bond for Jennifer Crumbly at $500,000 cash surety, no 10%. In the event that Jennifer Crumbly is able to post bond, the following conditions.
Oh boy, I swear, if they get released, there's going to be a lot of petitions started to get them locked up and their attorneys locked up too, I bet. So let's continue watching it.
Conditions will be in place. The defendant is not to use or test positive for alcohol, recreational marijuana, or any controlled substances. Ms. Crumbly is not to possess or have in her possession any firearms or dangerous weapons. She'll not have any assaultive behavior toward anyone. Must provide a release address upon release to the Pretrial Services representative. The Pretrial Services representative will be monitoring bond compliance. The defendant, within 24 hours of release from the Oakland County Jail, must submit to and pay for ETG, PBT, or urinalysis at a facility that's open 7 days a week that automatically lab confirms all positives, provides all levels in writing. That would be at the direction of PTS. The defendant, Ms. Crumbly, at this time is to verify any employment status and verify that in writing upon release from the Oakland County Jail. In the event that the defendant, Ms. Crumbly, is able to post a bond, the court is going to require that she have a GPS tether. The GPS tether must be installed upon release from the Oakland County Jail. The GPS tether will have the allowances that she could go to work, attend court hearings, medical appointments, and attorney meetings. She must provide work schedule, medical appointments, and any meetings to PTS in advance. Again, that must be installed at the jail before she leaves the jail. As it relates to James Robert Crumbly, the court is setting a $500,000 cash surety, no 10% bond. The defendant is not to use or test positive for alcohol, recreational marijuana, or any controlled substances. The defendant is not to possess or have in his possession any firearms, weapons, or ammunition. The defendant is not to have assaultive behavior toward anyone. The defendant must provide a release address if he is able to post bond to Pretrial Services. He will be monitored by Pretrial Services, must submit and pay for ETG, PBT, and a urinalysis within 24 hours of release from the Oakland County Jail at a facility that is open 7 days a week, that automatically lab confirms all positives, provides all levels in writing. The defendant must verify employment to PTS upon release from the Oakland County Jail. The GPS tether must be installed prior to release from the Oakland County Jail in the event that the defendant is able to post bond. He also must provide information relative to employment schedule, medical appointments, or any other appointments that are allowed, which will include he could attend court hearings, employment, appointments, and attorney meetings. Any violations of any of the terms and conditions of those bond may result in revocation of bond. Any question as it relates to bond for James Crumbly?
Your Honor, we have no questions, but I do need to place one thing on the record. I'm not asking the court to change anything. What I want to state on the record is I was not able to watch the entire press release and what I had no idea there was a 4 o'clock arraignment. Ms. Lehman didn't know either. The media had so many reports of random times that quite frankly, we didn't believe there was.
Counsel, we're not going to get into.
I just want to apologize to the court because we weren't aware. And also we faxed over appearances and no one told us like, hey, we're going to do this at 4 o'clock. We sent appearances late in the day. And I just apologize to this court because we don't miss dates. So thank you.
Thank you. Finally, as it relates to and in the event that the defendants do post bond, I am requiring that they turn over any and all weapons to the Oakland County Sheriff's Office. That must occur within, realistically, I'm not sure what they have in their possession or to be able to be where they're going to be released to if they post bond, but I am going to require that they turn over all weapons upon release from the Oakland County Jail.
We're almost to the end of this, but what I want to say is the crocodile tears were very fake. There were not real tears. Heck, I could even do better acting than that. But those tears were indeed real fake. Let's finish it off.
Okay. Any other questions?
No, thank you.
No, Your Honor. All right, again, the PCC is at the 14th at 1:15. Preliminary examination is on the 22nd at 9:45 a.m. It will be in-person proceedings. Please make sure that you are prepared with all witnesses and or exhibits.
Your Honor, I just do want to put on the record that there are hundreds and hundreds of hours of digital evidence and voluminous documents, and we are compiling it, and we'll get it to defense counsel as soon as possible.
Okay, thank you.
Thank you.
Your Honor, have a nice day.
Thank you, Judge. Your Honor.
First, thank you for being here today to hear the update on where we.
Now we're going to listen to a little bit of this one, and then I'll close this out.
we are. Obviously, this has moved forward on lots of levels. So as it relates to the two suspects that were charged, the parents that were charged by our prosecutor, Karen McDonald, as you know, we activated a manhunt when charges were issued to locate them immediately. Our partner from the United States Marshal Eastern District, Owen Cyphers here, they, along with a lot of partners, quite frankly, immediately went into action. In addition to our fugitive apprehension team, their teams, Detroit Police was amazing, and we can get into that more. Obviously, we had the FBI involved, Michigan State Police. We even had helicopter assistance from the United States Border Patrol. So everybody pitched in. We were confident we'd be able to find them in short order, and because of that teamwork, we did. So we were notified by Detroit. They had received a tip that the vehicle had been seen. We were notified at 23:05, which is 11:05 p.m. Our fugitive folks arrived on scene with Detroit at 23:25, which is 11:25.
As a creator, having access to ArtGrid's industry-leading stock footage
just 20 minutes after the call, they arrived downtown Detroit to be with Detroit. Detroit had seen the car, had secured the scene, had established a perimeter, done some great police work. Ultimately, at approximately 1:30 in the morning, the two suspects were taken into custody at 11 Bellevue in Detroit in a commercial vehicle. They were in an art studio within that building that has multiple kinds of partitions, if you will, in that building. They were taken in custody, as I said, at about 1:30 in the morning. Our fugitive apprehension team took custody and possession of them, and they were formally lodged in our jail, where they remain at about 0300, about 3 o'clock in the morning. So they are in our jail. All three of them, the son and both parents, they are segregated, each individually in isolation. We have advanced watch on them. There is no indicator that any of them, we always have every person that comes in an intake evaluated by counselors and classification to determine if there's any threats to themselves or anyone else. There was no indication that any of them were suicidal, but out of an abundance of caution, our amazing corrections team is doing suicide watches on all three of them. So they are in custody and again in isolation. So that's a good step. The further on as it goes to this, we believe, and I've had multiple communications with Chief White of Detroit, our great partner, and another, again, shout out to his team for what they did, how they did it. And we've been in conversation and talking about some of the now follow-on information and evidence that we have. We believe they were assisted in that location to get there, to get in, and we're gathering that information, and we're going to have the totality of that done fairly soon and present that to our prosecutor for potential charges for either aiding and abetting or obstruction of justice. So that will be a determination by our prosecutor at some point in the near future, and that is a work in progress with all the other works in progress. Again, you know, every time I get a chance, I want to throw out there to the public, if they have any information on either of these two or the individual, the shooter, please either contact us at OCSO, Oakland County Sheriff's Office, OCSO@oakgov.com, or call us at 248-858-4911. Any information, again, about either the actions in the school, preceding the actions in the school, or the follow-on as it relates to the two parents. And of course, you can be confidential or pass that on in any way that you see fit. I know Mr. Marshall from the United States Eastern District, you want to mention something there?
Yeah. Thank you, Sheriff. Good afternoon. My name is Owen Cipher. I'm the U.S. Marshal for the Eastern District of Michigan. I would just like to say thank you on behalf of the United States Marshal Service to the Sheriff's Office here in Oakland County. Sheriff Bouchard and his team have always been phenomenal. We've always had a terrific partnership with the Detroit Fugitive Apprehension Team and his staff. Our officers responded the moment that we got the tip that the vehicle had been found in Detroit. And we had units out working all day yesterday. And last night they converged on the scene and were able to help the Detroit Police Department take those subjects into custody. I would also like to thank Chief White and his team down in Detroit. They did a phenomenal job of identifying the vehicle, locating the subjects in a building that they believed they were in. As soon as we had enough personnel on site to search that building, we did so. We executed the warrants, and thankfully, no one was hurt in the apprehension of these two individuals, and they are now safely in custody. So great thanks to Chief White and to Sheriff Bouchard and the Oakland County Sheriff's Office, Detroit and Oakland County. They've always been great partners with the Marshal Service, and we truly appreciate that. So thank you, Sheriff. Thank
you. I think that's really most of what the questions have been about so far today. Anybody else have any other questions?
What did either of the parents say anything either on that drive from Detroit to the jail or once they arrived at the jail? Have they said anything to you?
Yeah, probably at this point, we're not going to talk about any either spontaneous utterances or discussions, because that will now become part of any evidence that may be presented. So that information will be turned over to the prosecutor, and anything about that will be forthcoming as it relates to, trial activities.
The Crumley's attorneys basically described this as a miscommunication and said they were planning to turn themselves in. Is that a possibility?
Well, all I know is this, is that when we were informed we had an active warrant for them, there was some communication that came in to one of our detectives that said that they were going to arrange for their arrest to turn themselves in. And, that's fine. We don't wait for that. When we have serious charges like felonies, you can turn yourself in, you can go to court, you can come to any one of our substations, but we're going to go look for it immediately. And so we triggered, once the warrant was in hand, a full activation of looking for them, because there's a lot more tools at our disposal once we have a warrant. And we had been looking for them prior to that, but it was in a much more limited fashion, and that's the most I'm going to say about our investigative techniques. But then later in the morning, we had communication that the couple was not responding to texts or phone calls of their attorney. So again, to us, that's irrelevant. We're looking for them. If they show up, fine. But we're not going to sit at the front desk and tap our fingers until they come in. We were out actively looking for them, working with our partners, and they were taken into custody before that question was asked or answered. Were they actually going to do it? I don't know. But given that they were hiding in a warehouse in Detroit, it certainly raises my eyebrows.
Why were they in Detroit to begin with?
That's part. That's part of the questions, obviously, why they were there, why they were in a commercial building in that form and fashion. We had located their other vehicle at a different location, prior to the warrant even being issued. As I said, we began a process of doing what we could before any warrants were in hand to look for them. And we found one other family vehicle at a different location, but they weren't there, and there was no connectivity to them being there at that moment.
Sheriff, can you give some clarity as to how you know that they were hiding? Couldn't they just say they were in the building when they specifically ducked away or anything like that?
Well, when the tip came in, the person was apparently outside smoking, and they pretty much ran away. And obviously, the way, and I'm not going to get into specifics, but I think where they were and how they were seems to support the position they were hiding, and they weren't looking for surrendering at that point.
Sure. What are the criminal
ramifications for the people that helped them into that art gallery, and what are they looking at crime-wise? Have the people that helped them been taken into custody, and are they cooperating?
Well, we obviously don't have any charges at this point, but that's part of the investigation. And ultimately, if there are charges that are applicable, that will be the prosecutor's decision. So we're trying to put together as much detailed information on that as it relates to that. Suffice to say, we have enough early indications that clearly somebody helped them into that location and made it available to them. And it was after it was publicly announced that there were warrants for them.
So that's the end of this video. Y'all already saw some of this one, and then y'all saw the full one of the other one. So I'm kind of done here. If y'all have any questions, you can DM my social media, which will be in my description below. And if you have any questions about this, just comment your opinions down below. And I'll see y'all in the next video. Or if I end up doing my Vlogmas, y'all can swipe up and watch my Vlogmas. Have a good day.